Okay, members, welcome to the meeting of the Justice Committee. To those in the room, members, the Deputy Chair and myself, and then the office staff. Just to outline the key issues in relation to today's business: the Committee Informal Deliberations on the Damages Return on Investment Bill, update on the Protection from Stalking Bill, Police and Crime Sentencing and Courts Bill, proposed LCAMs, and the progress of the Public Service Pension and Judicial Officers Bill and associated LCAMs. Also, proposal for 7 statutory rules, and then a written paper on the annual renewal of the Secretary of State's direction under Section 1A7 Prisons Act as amended Schedule 4 of the Northern Ireland Act 1998. We also have an update on EU exit and justice-related issues. To welcome also those members who are joining us via Starleaf. I will endeavour to ensure that I bring you in when you raise your hand or wave very forcibly at the screen, either whatever way you can get my attention. Just to remind members in relation to the use of mobile devices, they are able to be used as long as they're in the airplane mode and all devices are muted. This also includes the members' tablet devices. They can connect to the Assembly Wi-Fi. Can I remind also members that we are obliged to declare any financial or other relevant interests which might reasonably be thought by others to influence our approach to the matters under consideration. Any member who has an interest to declare in relation to today's business should do so now or when the particular matter arises in the meeting. Can I have your agreement for the Committee's informal deliberations on the Damages Return on Investment Bill to be reported by Hansard? Agreed. Thank you. Agenda item 1 is the apologies. We have an apology from Emma Rogan. Rachel and Gemma are joining us by Starleaf, and as we have noted, we welcome them to today's meeting. Doug and Peter will be attending in person. However, Peter will be joining us later around 2:45 p.m. We haven't heard anything in relation to Robin, so we don't know whether Robin is intending to be with us. Can I welcome the Deputy Chair in person? It's good to see Sinead here, and also to advise members that in terms of delegated authority to vote, Emma has delegated her vote to the Deputy Chairperson, Sinead. Item 2, the draft minutes. Yes, Sinead?
Sorry, can I just record my attendance? I wasn't sure if I was in audience. Thank you.
Yes, thank you. Agenda item 2, the draft minutes of the meeting of the 16th of September, which is pages 5 to 20 of the meeting pack for the draft minutes of the meeting. There is a minor typographical error in the minutes at page 17 of the meeting pack. The title for the third item in correspondence should read Case Processing Time for Criminal Cases Dealt with at Courts in Northern Ireland in 2021, not 2021-22. So with that typographical error, are we content that these are a true reflection of the proceedings of the 16th of September?
Content.
Thank you. Agenda item 3, matters arising. Item 1, in relation to the Examiner of Statutory Rules report. At last week's meeting, the committee noted the views of the Examiner of Statutory Rules, which he had provided in writing in relation to SR 2021/2011, the Northern Ireland Police Fund Amendment Regulations 2021, SR 2021/112, the Police Rehabilitation and Retraining Trust Amendment Regulations Northern Ireland 2021, agreed that she was content with both rules. The Examiner has written views. The Examiner's written views have been included in her second report, which was published on Friday the 17th of September and is found at pages 22 to 33 of today's meeting pack. this is to note the Examiner of Statute Rules second report. Noted. Item 2 is the Committee Forward Work Programme for September and October. The updated Committee Forward Work Programme for both September and October, reflecting the changes agreed at last week's meeting, has been provided at pages 34 to 39 of the meeting pack for information. Item 3, the Troubles Permanent Disablement Payment Scheme. The Clerk met with the Clerk of the Executive Committee, as we had indicated last week, to discuss where responsibilities sit in relation to the Troubles Permanent Disablement Payment Scheme and the role of the Executive Office. Following the correspondence from the Department of Justice, Michael Porter is seeking confirmation of the position from the Executive Office and will then update the Executive Committee. In the meantime, a letter requesting additional information identified at the meeting of the 9th of September has issued to the TEO, given it appears it sits with them as sponsors of the Victims Payment Board. So, really, the chair of the Executive Committee is also aware that this committee wants to hold an informal meeting with the Victims Payment Board, and further discussions will take place on this with the aim of holding that potentially in conjunction with the Executive Committee members before 7th of October, when we are due to have in front of us the representatives of Capita and also the department officials. So I think that this is an issue, members, we just need to try and tease out so that there is no ambiguity or confusion in the minds of any individual or organisation or the system as to who has responsibility. So I think, I know it was the sense of the committee last week that this is something we just need to keep a working brief on till we get clarity and certainty, and then we will know who has responsibility for what. Item 4 is the Damages Returnment Investment Bill Committee Informal Deliberations. And this is, members, where we will indulge your help and assistance as we try to work our way through this piece of legislation. And can I just say, to set a context, the information in relation to this part of today's business is found in pages 41 to 205 and pages 3 to 32 of the table pack for relevant papers. Really, the table pack is the letter that has been sent to myself as the chair from the Association of British Insurers, who have had different correspondence over the period of time that this has been considered. At our meeting on the 9th of September, the committee considered a response to the Minister of Health regarding the increase in indemnity costs for GPs in Northern Ireland and the implications as a result of the discount rate, and agreed to write to the Minister of Finance to ask if funding would be available from the Treasury to cover some or all of the costs of a state-backed GP indemnity scheme if introduced in Northern Ireland, and whether we get any sort of Barnett consequential funding from the scheme introduced in England and Wales, and if so, how this money would be allocated. The Finance Minister has confirmed that the Executive will have received Barnett consequentials associated with the introduction of the state-backed GP indemnity scheme in England and Wales. However, it was calculated based on the overall Department of Health and Social Care spending review settlement, and it is not possible to determine the specific amount. The funding received would have been utilised according to the Executive priorities, given the financial pressures faced at the time, and Treasury has confirmed that no further funding would be provided if such a scheme is introduced in Northern Ireland. The costs, therefore, would have to be funded from the health budget settlement, and the relevant correspondence in relation to that is found in pages 10 and 11 of today's table pack. Unless there's any other information or clarification required in that, I just leave that for you to note and consider. Okay. The correspondence has, we've received, as I mentioned just a few moments ago, we've received correspondence from the Association of British Insurers asking the committee seek clarification of 2 points that arose during the evidence session with officials on the key issues in the evidence received on the bill at its meeting of the 9th of September. The ABI has also stated that the Department has not provided any evidence of undercompensation in settlements using the personal injury discount rate, yet it maintains that the further margin of adjustment of 0.5% is required to reduce the risk of undercompensation and achieve 100% compensation. The ABI believes that including this adjustment exceeds the aim and principle of 100% compensation should be removed from the bill by the deletion of paragraph 10(2)(b) at line 21 of page 6 and encourages the committee to consider such an amendment. The relevant correspondence can be found at page 14 to 32 of the tabled pack in your papers today for this meeting. Martin Moore from the Department of Justice will be available via Starleaf if members have any questions or require any further information or clarification of any issue, including those raised by the ABI during our informal deliberations. The committee will now undertake its formal deliberations on the clauses and the schedule of the bill. Departmental officials indicated on the 9th of September that the Department does not intend to bring forward any amendments to the bill at consideration stage. The informal deliberations provide an opportunity for members to discuss the issues raised, indicate whether they are content with each of the clauses, or whether they require any further information or clarification, or whether they wish to amend the particular clauses or are minded to reject particular clauses. If members need more time to consider a particular clause or clauses, the committee can continue its deliberations at another meeting, but the committee stage of the bill must be completed by the 22nd of October, and this includes agreement of the committee report. And as you can appreciate, that is a considerable amount of work that has to be done, and is something that we need to bear in mind in terms of how we expeditiously work our way through these clauses today. And I just notice that we have Martin has now joined us in Starleaf. Martin, thank you for being with us, and hopefully your services won't be needed too much during our deliberations today, but thank you for being with us this afternoon.
You're welcome.
Thank you. Just also to say to members that if the committee is minded to make amendments to any of the clauses, the purpose and desired outcome of the amendment needs to be clarified. The committee may then wish to write to the Minister of Justice asking whether she accepts the proposed amendment change and will table an amendment. Alternatively, or at the same time, the committee can ask for a draft amendment to be prepared by the bill clerk for its consideration. The bill clerk, Stephanie Mallon, will be listening to the committee's deliberations today, and if the committee indicates that it wants any draft amendments prepared, she can join the meeting to provide advice and seek clarification of the purpose of the proposed amendments if that is necessary. Given advice from the bill clerk to a committee takes place in closed session, this will happen at the end of the deliberations rather than during the time, in case there is more than one proposed amendment to be discussed. So, members, you will now work our way through the bill. The clerk's paper setting out the purpose of this session and the process is at page 41 to 43 of the meeting pack, and a paper setting out the key issues to the committee that the committee may wish to consider during the deliberations was emailed to members yesterday and can be found at page 3 to 9 of the table pack. So if there's no questions or queries in the light of all of those introductory remarks, can we then move to clause 1 of the bill? And clause 1 provides that the rate assessor is the government actuary, provides that a court must take into account the rate set by the state assessor, preserves the ability of a court to take into account a different rate, and introduces new Schedule C1, which is inserted in the 1996 Act. In terms of the key issues raised in relation to this clause in the evidence received to date, they include whether responsibility for setting the PIDR should sit with the Government Actuary in accordance with the framework set out in the bill, or whether the responsibility should remain with the Minister of Justice or sit with the Executive collectively. Also, if responsibility for setting the rate is to remain with the Minister, who, at a minimum, should the Minister be required to consult with before reaching a decision. The other issues raised, whether the Department should be required to publish an impact assessment before a rate review is due, setting out the potential impacts of different rates on Department businesses, and also whether Clause 1.1 subsection 2 is required or should be removed. And really it's to seek members' views of Clause 1 of the bill, the issues raised and the evidence received, and whether we are content with the clause and whether we wish to amend it or require further information, or whether we wish to discuss rejecting it or wish to highlight any view or comments for inclusion in the committee's report. The one point I would raise is the issue in regards to the requirement to publish an impact assessment before a rate review is due, setting out the potential impacts of different rates on departments and businesses. I think that would be useful. But am I right, Christine, that can be done in the report?
Yes, if the committee would like to support that recommendation, then we can put it into the report. I don't think it requires to go into the actual bill, but we can put it into the report as a recommendation to the department.
Members content that that would be the case?
Sorry, Chair, could you just reiterate that again, please?
What it would be is in the report that we would do in regards to the bill, that the department should be required to publish an impact assessment before a rate review is due, setting the potential impacts of different rates on departments. I think it might give us some sense of where all of this is likely to go. Okay, content? Any other comments in relation to Clause 1? Welcome, Robin. Thank you for attending. And also Doug, who's now joined us. Apologies, Doug.
Apologies for being late, Chair.
That's all. Okay, members, if we are content, then we'll work our way through the key issues as we've done, and if there doesn't seem to be anybody indicating that they wish to amend the clause or the purpose or the desired outcome of the amendment or any of that, so if we are content, Kristen has put a note here that if the committee was to decide it did not wish to support Clause 1, that provides for the Government Actuary to be the rate assessor, and the bill clerk will need to attend at this stage, but there's nobody indicating. Rachel, you have put your hand up, sorry. No?
Sorry, Chair, I don't know if you can hear me okay?
Yes, we can, Rachel.
Okay,
yep.
sorry. It was just in regard to Clause 1 on subsection 2, and I know that this had come up before by IUAL about it being necessary. It may be something for us to put into the report as well, just about that, but I know the department had indicated that it's already in the Damages Act and there's case law, but maybe if it's to be made specific, even with an AFM change, if that would be of assistance.
Yep, and I think that would be useful to have included in the report. Okay, yep, agreed. Content?
Thank you.
Okay, thank you, members. So, if there's no other issues in relation to Clause 1, okay, can we then move to Clause 2? Clause 2 inserts a new Schedule C1 into the 1996 Act, which sets out the detail about how the Government Actuary is to approach the task of reviewing and setting the discount rate. No issues were raised in the evidence in relation to this clause. The issues raised relate to the specifics of the schedule, and we just to seek your views on Clause 2 of the bill and whether you're content with the clause. I'm taking it, if no one has indicated, that we are content. The new Schedule C1 is paragraphs 1 to 6, and paragraphs 1 to 6 of the new Schedule C1 provides that the first review carried out by the Government Actuary is to be a review of the current rate, deals with the timing of subsequent reviews, and requires a review to take place on the 1st of July 2024, and thereafter establishes a 5-year cycle of regular reviews, requires any review of the rate to be concluded within 90 days, and provides that the Government Actuary can consult or seek advice from any person and must have regard to their views if received within a reasonable time. Most of the responses are supportive of the timing of the reviews and the proposed 5-year cycle. However, one organisation recommended that the review period should be 3 years rather than 5 years. And maybe, Martin, could you maybe give us a sense of what would be advantageous if it was 3 as opposed to 5, or what would be the challenges or difficulties if it was 3 as opposed to 5?
Well, the advantage would be the rate would be reviewed sooner. So if there were circumstances that changed in the interim, the rate would be reviewed and corrected, so to speak. Having said that, there's a provision in there also that allows an extra review to be done. So if circumstances arose, economic circumstances or whatever, that caused the rate to be deemed to be out of kilter with what it should be, that could happen in any case. The disadvantage of 3 years is it's probably short enough a period of time that it might encourage parties to game the system by delaying settlements. If a case arose with 18 months or a year before the review is due, that might be sufficient time for delays in the negotiations and so on, if one of the parties felt that a review was coming which might change the rate in their favour. So the idea is that 5 years is the best, the optimum period, in that it reduces that opportunity for gaming, but nonetheless 5 years is still a fairly regular period for the rate to be reviewed.
Okay, any comment by any member? Are you content with that?
Content.
Content, okay. Just also in relation to the new Schedule C1, paragraphs 7 and 8, the paragraph 7 and 8 of the new Schedule C1 provides that the rate should reflect the rate of return for the notional portfolio over a 43-year period, and gives the Department of Power by regulations to subject a draft affirmative procedures to change the period of the 43 years to another period. Now, just to give you, and apologies for there being a lot of reading and words in this, but I just want to maybe give you a sense of what were the key issues that were raised in relation to these paragraphs in the evidence that was received. And they included whether a 43-year investment period for the setting of the discount rate is appropriate as opposed to a 30-year period, whether the GAD should factor longevity based on available statistics into any future analysis and modelling as proposed by the FOCIS, whether if the 43-year period is used, a further margin of adjustment of the 0.5% in addition to the adjustments provided at paragraph 10 of the schedule should be included to mitigate the broader risk of undercompensation as proposed by FOCIS but opposed by other organisations, and whether the department should be encouraged to gather data on the average investment period for claimants in Northern Ireland to inform any future consideration of whether to change the assumed period of the investment. Sinead Bradley.
Thank you, Chair. Appreciate you raising that point, because it is worth noting, we have taken very much a model and tailored it without really any full explanation in that regard in terms of the timeline. But I just wonder if we could get some response, or I suppose rebuttal to the points that have been raised against paragraph 9 and 10, and that is, the one is about measuring it against RPI, and I believe the government are planning to move from that position, and does this bill allow for an easy step in and to correct it if that is what happens? And also, could we have the departments, you know, we're being told, and I appreciate different parties have different agendas in this, but we're being told that the further adjustment is unnecessary or can result in overcompensation, and I'd just be interested to know what the department said to that. Thank you.
On those 2 points, Sinead, we'll come to those. We're not at those at the minute. We're just dealing with this, the clause 2. So if you can hold those, then we will deal with those when we come to them in a moment or two. All right. Just so that it's for our own sanity in terms of us trying to work our way through this.
Sorry, Chair. I'd understood that was coming under part of this early clause.
No, not your first part. What we're looking at here is in relation to the period of the 40, well, it's the 43 or the 30-year period. Martin, do you want to make a comment on that? Maybe do you want to deal with those issues that Sinead has raised?
Sorry, you want me to talk about the 43 years?
Yes.
Well, the 43 years is really the only period for which there is any evidence that we're aware of. As part of the call for evidence that the Ministry of Justice made when it was setting its rate, there was evidence provided that the average investment period for a claimant was between 40 and 45 years. So the 43 years then is the midpoint of that estimate, and the Lord Chancellor subsequently chose to assume that period in 2019, and the department's view here is that it's better to use that evidence-based period rather than the 30 years, which is essentially an arbitrary figure that was used in Scotland.
Okay.
Sorry, Chair.
Yes, Sinead.
Sorry, could I come back on that? Maybe I'm not making my point clear. It's just that I can't help but feel that these are interlinked, because at one stage we have taken a Scottish model, made a determination separate from the Scottish model in terms of extending the years, but surely then we have to then look at the ramifications of that in terms of the other pieces which I refer to, because I think they are all interlinked. So if we are moving to, which is for argument, you know, that if it's a more representative number of years, then we also have to be cognizant of the fact that that could extend the potential return on the investment, and therefore we have to visit the other pieces that sit there that are the levers for over or under compensation. So I find it very, you know, I do find it difficult to look at one of these individually without acknowledging the effect, the knock-on effect it should have on other, or potentially could have on other parts of the bill.
Yeah. Martin, do you want to make a comment?
Well, in relation to this, our perspective is these are all estimates. As we keep saying, as everybody knows, it's not an exact science. We're trying to use our best judgment. We're trying to estimate parameters within a framework that will best deliver 100% compensation in the round. So our perspective is what assumed investment period is most likely to deliver that 100% principle. The 30 years that was used in Scotland, there isn't any particular rationale to that. The 43 years, there is some evidence to support that, and on that basis, we think that is the most reasonable period that should be assumed. So it's not a case of whether it increases or makes overcompensation or undercompensation more or rather, it's not the case of what is the outcome of doing this in terms of, will 43 years provide more compensation than 30 years? It's which is the appropriate assumed period, and we think it's 43 years.
Sinead?
Thank you, Chair. I accept that as a standalone argument, but I do see how it interweaves in with the later part of the bill. So ultimately, are we declaring that the Scottish model have it wrong? You know, are they not achieving 100%? Or, you know, where's the redress in their bill? Because I just really am struggling to not connect this to the later parts of the bill. I accept the argument and I think it's probably right, but I do think it has knock-on consequences that don't seem to be filtering through to my mind at this stage. Thank you, Chair.
Thank you, Sinead. And Martin, in relation to that point, do you get, in terms of that correlation, the point that Sinead is trying to make in regards to the knock-on effect or the connection that there is between this part and probably the other part in relation to paragraph 9 that we'll come on to about the RPI, is what is your view or the department's view in relation to the effectiveness of the Scottish model, or not the effectiveness of it, as the case may be?
Well, I'm not entirely confident that I can remember the timeline exactly, but I think I'm right in saying that the evidence for the 40 to 45 years was perhaps not available to the Scottish Parliament at the time that their legislation was being passed, and it was in a later exercise conducted by the Lord Chancellor. That evidence came to light, so that may explain why they went for the 30 years without the benefit of that evidence. If I've got that wrong, I can clarify subsequent to this meeting, but I think that's correct.
Okay. Sinead, keep your hand.
Yes, thank you, Chair. I won't labour that at this point, but thank you. Appreciate that.
No, it's important that members get the opportunity to, because that's what the purpose of this process is for. Just so then we are not minded to make any amendment or change to this, but I think it would be important, given the concerns that were raised by Sinead, that those will be reflected obviously in the report. Okay, so are we, just so we're clear, we're not saying that we want to change our amendment, we're content with the clause 2. Okay? Okay, thanks Martin for your help in relation to that. That brings us to the new schedule C1, which is at paragraph 9, and Sinead did make reference to this. And it requires an adjustment to the rate to take account of inflation as measured by RPI or such other measure of inflation as may be prescribed by the Department of Regulations, subject to the draft reform procedure. The key issues raised in relation to the paragraph and the evidence received included general support for the use of RPI, and if CPI should be used instead, it should be adjusted by a plus 1% as it was in England and Wales. Sinead, you want to comment on this part?
Yes, no, sorry, Chair. I think you just made the point well. It is just that that adjustment piece, whether we have provision for either making that alteration easily, and the only other one I want to raise was paragraph 10 at this point. But thank you, Chair.
Yep. Okay. Okay. So we're content, and we'll move then to paragraph 10 of the new schedule, C1, paragraph 10 and 11. And this requires standard adjustments to be made to the rate arrived at on the basis of a deduction of the 0.75 of a percentage point to take account of the impact of the taxation and the cost of investment advice and management, and a deduction of 0.5 of a percentage point as a further margin which recognises that there is a risk inherent in any investment. Paragraph 11 provides that the amount of the standard adjustment may be changed by the Department by regulations should and is also subject to the draft deferment procedure. So the key issues that were raised in relation to the reduction of the 0.75 of the percentage point. One was whether the standard adjustment of the 0.75 percentage is appropriate, whether it is too low as suggested by APIL and FOCIS, and should be amended to 1.5% to avoid undercompensation of claimants, or whether the standard adjustment for the taxation and investment advice should be removed from the bill and allow defendants to consider paying for the reasonable cost of future financial advice as a separate head of claim through negotiations or award at the time of settlement as that was proposed by AXA. Now, it's really members' views in relation to that issue. It has been raised with us on a number of times. There are slightly different views. It is a judgment call. It is an issue for us to ensure that we have given it due consideration, and it will be a judgment call on our part. Sinead?
Thank you, Chair. Yes, I would just like some clarification. I am not opposed to that it should be on the face of the bill, that there are costs associated with the management of an advice. Even though it's a notional portfolio, the expectation is that the claimant will be in receipt of money, and we should be, I suppose, encouraging good good behaviour, I suppose, for want of a better expression, with that money. So even if they don't go down the notional portfolio route of investment, that they are securing and taking good financial advice. So I think that's important to be on the face of the bill. But in terms of Part B of paragraph 10, the 0.5%, the additional further margin, I'm still not very clear, Chair, what actually that is. And I know that it has been suggested to us that it may not have to be there. And I certainly I'm not comfortable with it being there without understanding what it actually represents. So any clarity on that would be really helpful. Thank you, Chair.
Thanks, Sinead. Martin, you want to make comment in relation to the necessity of 10B being in the bill?
Well, the further margin, which is on the face of this bill, a similar margin was also applied by the Lord Chancellor in England and Wales, and he called it a margin of prudence, which is perhaps a good way of describing it. It's a recognition that, again, emphasising again that all of this is an exercise in judgment, albeit informed judgment, and that there is risk inherent in all of this. There's risk inherent in any investment. There's the notional portfolio itself. Everything in here is based on informed assessments and estimates of how things might happen in future, how investments might perform, albeit on the basis of expert advice, but nonetheless, there's still risks there. And the further margin really is a position to say, rather than having a 50-50 risk of overcompensation and undercompensation, that as a measure of prudence, we would rather that the risk was slightly in favour of the claimant rather than the defendant. The defendant is generally a large corporate organisation which is backed by large financial resources and is in a much better position to bear the risk than an individual claimant who is probably an individual person on their own. So without the margin, the expert advice tells us that the risk is a 50-50 one between overcompensation and undercompensation. Adding the margin just tips that balance of risk slightly in favour of the claimant, and it's roughly a 65 to 35% probability then of overcompensation rather than undercompensation.
Okay, apologies, Sinead, I can't see the screen, but I'll come back to you in a minute. Deputy Chair?
Yeah, so I just, so based on what was just said there now, my understanding is that yes, there could be some overcompensation, but what we're saying here is that those individual claimants won't be left out of pocket to acquire the things that they need in terms of, it might be house modification or whatever those expenses that they're going to occur. That's to ensure that they're not left, looking around to find out where that money's going to come from, that they're compensated for those things that they're going to need. Am I right?
The risk that a claimant will be undercompensated cannot be eliminated. There will always be that risk. So there's always the possibility that the initial calculation wrongly calculates what they need, or inflation increases more than was projected, or the investments don't perform as they are expected to perform, or that the person lives longer than they're expected to live. Any of those things could lead to a situation of undercompensation or of overcompensation. We're trying to minimise the risk that happens, and the further margin is saying that, accepting that risk is there, we think that the defendant is in a better position to bear slightly more of the risk than the claimant is. So it's just shifting the risk slightly towards a risk of overcompensation and away from a risk of undercompensation. But there's no formula that can remove that risk altogether.
Yeah, it's not an exact science, but we're hedging our bets, basically.
Yes.
Yeah. No, that's fine.
Okay. I'm just want to be sure, because I've lost my screen here to see who's their hands up. Sinead, on Starleaf, do you want to make a comment?
Yes, thank you, Chair.
Yeah, okay.
Chair, I really appreciated committee that being the answer to that question being on record, because as you'll be aware, Chair, we have all been charged with and the focus on the 100%, and that is for good reason. And I have every sympathy with then the explanation given, and I have no problem declaring that I would be on the side of the unfortunate claimant in these cases. So, if we did have to tilt the scales in any direction, that's exactly where I would want it to go. But that said, I do think it's important, and that's why the earlier point and connecting it with this one is so critically important, because if we are leaning in to the possibility of overcompensation to the claimant, we need to be at least aware of at every point in the bill where we may be doing that, because we could be leaning quite heavily into it. And that's why I'd just be really mindful of trying to connect all those points together, and then taking a wholesome view of, are we near the 100% as we can get. But thank you, Chair, appreciate that.
Thank you. And just to remind members that obviously we have correspondence in relation to this issue from the ABI, and in a sense, Sinead, what you've done earlier was, rehearsed some of those concerns. They believe that including the adjustment exceeds the aim and the principle of the 100% compensation, and their view was in the correspondence which is in the pack, in the table, in the table papers today, is they're saying that it should be removed from the bill by the deletion of paragraph 10. So I think that the point you make in relation to it's now on record and will be reflected in the report, and this is a judgment call that we have to make in terms of ensuring, and even the points that the Deputy Chair has made, is that we're doing this in the light of trying to ensure that the onus does not fall upon the claimant. And I think that is important for us to record. So are we content that it stays as it is, or do we wish to consider the amendment or the deletion of an element of the clause, or are we content as it is? Content at the moment, but it may be something that we may want to come back to. Okay. Okay, thank you. Just maybe that would be worthwhile just to note that that is the case. Thank you. That brings us to the new Schedule C1, paragraphs 12 to 15. And paragraphs 12 to 15 of the Schedule C1 sets out the notional portfolio of the types of the investment and the percentage holdings of each of the and the interpretation of the types of investment provides for the department to make regulation to define any of the types of the investment included in the notional portfolio, and provides for the department to have a power by regulations, subject to draft affirmative procedure, to change the list of investments and percentage holdings of the notional portfolio. The key issues that were raised in relation to this were such as whether the notional portfolio provided for in the bill is appropriate, particularly when considered in conjunction with the proposed further margin of adjustment of the 0.5 to achieve, as we have previously discussed, close to the 100% compensation as possible. Whether the notional portfolio is over-cautious as claimed by a number of organisations, and the proportion of equity investment should be increased within the overall portfolio to avoid overcompensation, or whether the notional portfolio should reflect the Wells versus Wales assumption of investments solely in index-linked gilts to ensure undercompensation does not occur. So on paragraphs 12 to 15 of the schedule, it really is for us to determine, are we content with these paragraphs, or whether we think there's anything else should be done in relation to reflecting some of those concerns or issues that were raised during consideration. Content? Okay, I move on, and if there's someone on Starleaf and you want to get my attention, just speak in case because my screen I can't see you putting up your hand, or so apologies for that at the moment. C1, sorry. Sinead, do you want to comment on that?
No. Thanks, Chairman. When I have the mic up now, I think the fact that we have been, if at one part of the bill we're trying to reflect what a normal period of time is for an investment, then I think it's reasonable to also take a real world view of what an investment looks like, as opposed to just going down the gilt route, So I think that is more consistent, probably, in approach. Thank you.
Okay, thank you. Excuse me. The new Schedule C1, paragraph 16. This provides for a review of the rate is due to start. The department must consider whether the notional portfolio remains appropriate with references to the characteristics and objectives of the hypothetical claimant investing and award of damages as described in paragraph 16. And it's whether or not we are content. I think there was no real issues that were raised in relation to that. We're content. Mm-hmm. That brings us on to paragraphs 17 and 18 of the new Schedule C1, and it describes the characteristics and objectives of the hypothetical claimant investing and award of damages, and clarifies the type of damages in the question is a lump sum award of damages for future financial loss. Some of the issues that were raised in relation to that was whether the description of the hypothetical investor is accurate, whether there should be a duty on the Department of Justice to gather evidence, commission research of actual claimant investment behaviour as proposed by a number of organisations, and if not, a legislative duty, the committee may wish to consider recommending this in the bill report. And I would suggest that maybe that is what we do reflect in the report in terms of the issue of the department gathering the evidence, and maybe to commission some report or research on, and I know this is probably, it is a task trying to get this particular information, but I think it might be useful so that there will be some sense of what is the investment behaviour in terms of a number of organisations. Are we content that we would do that and reflect that in the report? Any other item? Martin, have you any comment in relation to that? Because I know it might have been raised before by officials that it might be difficult to garner that information, but do you think that still would be possible?
Well, I think it would be difficult. It's hard to conceive how the department would be able to find out how people who the claimants were in the first place, and how they had invested their damages. And hard to see how you could place an obligation on anyone to provide that information, even if we were able to track them down and ask them.
Yeah.
The evidence that has been available to date has really been provided by financial advisors, so it's really second-hand evidence as to how they believe, or how they believe advisors would advise people to invest, rather than what they've actually done once they get the money, which is really their private business.
And although having it reflected in the report, that then equally can be assessed, and maybe that is something that the department might further give us a response on, so that we have tabled it out as best as we possibly can. But see, the other point, Martin, in relation to whether the description of the hypothetical investor is accurate. Do you want to comment on that?
Well, this is really the part of the bill that sort of ensures that the notional portfolio will seek to achieve 100% compensation, because it's specifying that it's an investor that needs to invest money to receive the money that they need, and that will be exhausted at the end of the period that they need it for. So in other words, they get everything required to meet their needs, and no more and no less. And then the department is required, every time there's a review, to make sure that the notional portfolio meets those criteria. In other words, that it still meets the 100% compensation principle.
Yeah. Okay. Okay, members, if there's no amendments or further comment, we'll move on then to the new Schedule C1, paragraphs 19 to 34. Is that right, Christian? Is that where we're at now? Yes. Yeah. So paragraphs 19 to 34, Schedule C1 provides for the rate to be set as a percentage figure and rounded in the nearest whole number or quarter percentage point, provides for there to be a single rate which will apply to all cases unless the department by regulation requires more than one rate to be set. It provides for the government actuary to send a report of his review to the department, and sets out the information which the report must include, requires the department to lay the report before the Assembly as soon as practicable, and after it is received from the government actuary, to publish the report on the same day, provides that the rate is determined will come into effect on the day after the report is laid, and provides for reimbursement by the department of the government actuary costs. The paragraph's also transitional provision sets out for the procedures for regulations made by the department, includes an interpretation of the provision. The proposal was made by one organisation that the rate should only apply to compensation awards relating to incidents that took place after the change in the rate, rather than at the time the damages are awarded, as the legislation currently provides for. And is there any comment in relation to that particular issue, or are we content with the paragraphs 19 to 34 of the schedule? Content? Okay. Thank you. That then brings us to clauses 3, 4, 5 and 6 of the bill. That concludes the C1. Clause 3 makes ancillary provision. Clause 4 is an interpretation provision. Clause 5 deals with the commencement. Clause 6 sets out the short title of the bill. So there was no issues raised in relation to those, so we're content. Okay, in conclusion then, members, just in terms of other issues that were raised, there were a number of other issues that were raised in the evidence received in regards to the bill, and so that we have them recorded and before ourselves again, can I just summarise a few of them? The consequences of changes to the PIDR on the health service and the health care professionals, in particular GP indemnity costs, that they should be borne in mind and considered when setting the rate. The need for a state-backed indemnity scheme for GPs in Northern Ireland, similar to that introduced in England and Wales, when the framework for setting the rate changed in those jurisdictions. The need to promote the use of periodical payment orders, particularly in cases against the health service, so that as many cases as possible are settled by PPOs, which removes the responsibility for the claimant to manage very large sums of money and provides the assurance of a continuous annual income being received every year for the remainder of their life, and the potential impact on insurance premiums and the implications of this on car insurance, businesses, etc. And that should be considered and taken into account when setting the rate. The information on this should be published when the rate is being reviewed or changed to ensure businesses are aware of the potential costs. Then finally, the legislation needs to be progressed as soon as possible to enable a new rate. And I think this is really what has been driving a lot of the concerns, certainly over the last period of time, is about having this progressed so that the new rate is set to minimise the potential impact of the -1.75 rate recently set by the Department under the current Wales versus Wales methodology. So those were just a summary of some of the other issues. Martin, can I just raise this issue about the need to promote the use of periodical payment orders? And has the Department taken any proactive steps in relation to addressing that particular problem? Because it does seem to be an issue that it has sort of been left out there, and there doesn't seem to be much that gives us a sense of confidence that's being used in the way that it was intended.
No, there hasn't been anything done to promote the use of PPOs. At the minute, the provision is there. We understand that it's not used particularly often, and that is because either one party or the other or both simply prefers to take the lump sum.
Okay. Robin, you have your hand up, and then Sinead.
Thank you, Chair. It's really only to ask permission to leave the meeting for a short time, if that's okay.
Can go to the toilet. Permission granted, Robin.
Okay, Chair. Thank you.
Thank you. Appreciate that. Sinead.
Yes, thank you, Chair. It was again on the matter of the PPOs, because I just am really aware that on the face of the bill now, we're saying ultimately when a settlement is made, that discount rate at that moment in time will apply, because it is assumed that it is that the claimant is in receipt of a lump sum. So the PPO, even if that agreement is set up by the parties, the anchor, I suppose, will be on this bill as it stands, that the discount rate will have been calculated at that one moment in time, and therefore the payment over the trajectory of the time remaining will not be subject to any levers of review or any dramatic changes to the discount rate. That won't be taken into account. And I'm just wondering, is that wise? Is this an opportunity for us to reinforce the strength of the PPOs? Because when I think of PPOs, I particularly am mindful of those claimants who may have safeguarding issues and may be reliant on the goodwill of others to protect their long-term investments. And I just am putting that out there because I wonder, is this bill the opportunity to make a PPO a more realistic and safer option for a claimant to consider?
Okay, can we just hold that 1 minute, and then can we bring in the Deputy Chair, Sinead?
Thank you, Chair. Yeah, it's just the issue of the indemnity scheme. So given what we've just learned at the start of the meeting in terms of the fact that we know Barnett consequential, I think it would be useful for the committee to understand or to get information from the Health Minister whether he is actively pursuing with the British Treasury an indemnity scheme, so that obviously we don't want the burden to be passed on to the health service or GP. So
okay, we can clarify that. Okay, agreed. Martin, can I just ask that point that Sinead Bradley has raised in relation to using this bill to take an opportunity to do something in regards to the periodical payment orders. What would that look like in terms of an inclusion in this bill? And how do you see that being of value? And obviously Sinead has set out how she would see that it would be of help. From the department's point of view, how would you see that would be achievable?
Well, perhaps the first thing we would probably need to consider as to whether that would be within the scope of the bill, because the bill is really about the discount rate and not about periodic payments orders. I think we do struggle to see how you could legislatively increase the use of PPOs. It's already possible for a court to order a PPO even without the consent of the parties. Naturally, a court is probably unlikely to want to do that, and I understand that the guidance or the rules that judges have to consider includes they need to consider that what both parties want to do and allow both parties the opportunity to argue for or against a PPO.
In terms sorry, Martin. In terms of whose responsibility it is to have the adequate information available in relation to the promotion of ultimately use is maybe a slightly different, because that could be in the hands of the court. But in terms of the responsibility to promote their use, does that not lie within the confines of the department? And if it's not if it's not the best vehicle, and we may not have concluded this yet as to whether it is or it isn't, but what would the department's view be about what it could do in relation to that issue to ensure that there is a promotion of the use of PPOs?
Well, this is probably a disappointing answer, but I don't think the department has really considered whether or not or how it would be the department's responsibility to promote PPOs. That I couldn't really answer that on the spot now.
Okay. Rachel?
Thank you, Chair. And I have some sympathy with that in terms of the department's responsibility of promoting it, but I'm wondering in terms of the courts, if there is guidance and rules in terms of how PPOs are decided on between both parties, and obviously the consideration of both parties, is this something that people are aware of? You know, we've discussed in many different bills throughout committee about the importance of training and information sharing and guidance and that sort of thing. But yes, the courts, as it seems, already have the power and there are options there for PPOs. But is that being put forward as an option? Because we don't really know. And that's where I have some difficulty with that, about promoting something that is already, and I understand the point, but promoting something that's already as an option, but maybe people don't actually know about it. And I just maybe, thinking about that from other legislation and other things that the committee's working on. But, in terms of the department promoting it, who would it be promoting to? Would it be the courts, in which case it can't? Is the courts are independent, but in terms of the judiciary, is that something that the courts and tribunal service should be doing? Could we recommend that maybe? I'm not too sure, because again, we don't have all the details on how this actually works in practice within the court system, within the two parties.
And Martin, on that point, is that something that you could get clarification for us in relation to what is currently the state of practice in terms of the current existence of PPOs? And if it's like a secret drawer in a cabinet, who's responsible for putting the drawer there in the first place? Whether people use it or not, that's another issue. But I suppose if you could give us some sense of that, then that might help us to determine, and we certainly can get further clarification as to whether an amendment would be within the scope of the bill. That's something that we can make progress of in relation to the committee. But that issue about where PPOs currently stand in relation to the available suite of information and available tools, is that something you think you could get us some more clarity on, to satisfy our minds that we haven't missed an opportunity to do something of value in relation to their promotion?
Well, I don't think there's any reason to believe that people aren't aware of PPOs. I mean, any solicitor will know that PPO is an option and ought to be advising his or her client as to whether they should go for a lump sum or PPO, or advising that they have the option of a PPO if they don't want to take a lump sum. That's the business between the solicitor and the client. Most of these cases don't end up before a court. They're usually settled before they get to court. If they do go to court, there's no reason to believe that the judge will not be aware that a PPO is an option.
Okay, members, I think there's probably something there that we want to come back to. So are you content that we give some for further consideration to that issue?
Yeah.
Okay. Content?
Thanks, Chair.
Okay.
I just make one that.
Yes, yes, Sinead.
Yeah, thank you. I suppose, Chair, what I'm in my mind, what I'm trying to think is, if it isn't about the promoting of a PPO, because a PPO may be the appropriate vehicle for one claimant and not another. And I think particularly of a very young person whose periodic payments may peter over a lifetime, where you have to really be mindful of that. And this bill, in terms of the setting of the discount rate, we're dropping an anchor at the point where that claimant is negotiating the settlement. And at that point in time, we're saying that is the discount rate that applies to you. Even if you take the PPO route, that discount rate will apply to you for the remainder of your settlement. And I'm just wondering, should this bill have somewhere in it the possibility for the PPO to be tracked, so that should there be a massive differential from the moment in time where the settlement was agreed and say 30 years later when the claimant is still in receipt of a PPO, should this bill be cognizant of that, as opposed to taking the assumption that it is one lump sum payment? And I think that's maybe what I'm trying to get at. Thank you, Chair.
Okay. Well, as we said...
Chair, could I clarify something there, Chair?
Yes, Martin, thank you.
It's just to clarify that if there is a PPO, then the discount rate isn't applied. The discount rate is only applied if there is a lump sum, because it's only if there's a lump sum that there's money to invest. The PPO is paid out regularly, so the money is used in real time, if you like. It's not invested and then the returns on the investment are then used to meet the claimant's needs.
Sorry,
So
I appreciate that, but we're making the assumption that it is a lump sum during that settlement period. The bill is saying that it's assumed to be a lump sum if there is a periodic payment. I think it's the hypothetical investor under section B. It says the damages are to be assumed to be received in a lump sum rather than by the way of a periodical payment on the face of the bill. So that's where maybe I have a bit of an issue.
Well, that's just clarifying that the discount rate applies only where a lump sum is awarded, and therefore the claimant has a large sum of money to invest. If the claimant opts for a periodical payments order, they will get the money paid to them on a regular basis, I don't know whether it's every year or every 6 months for the rest of their life. And that amount is then adjusted, as I understand, for inflation as well. So the question of the claimant having to invest the money doesn't arise, and therefore the discount rate doesn't come into it. So the provisions of this bill relate only to the application of a discount rate when a lump sum is awarded.
Okay, appreciate that. So you're saying but the settlement, before the periodical payments are set up, is the settlement amount not part of that? Would the discount not be factored into that?
Well, the parties will negotiate how much money is needed to meet that person's needs as a result of the personal injury. And if the person opts then for a periodical payment order, there's no need to consider how to take into account the returns on the investment of that, because the person isn't going to be investing at all. So the discount rate doesn't come into it at all in that situation. If the person decides that they want to receive a lump sum, then at that point the discount rate would be applied. If you look at clause 1 and paragraph, or the new paragraph C1,
Yeah.
which sets out really the purpose of what we're talking about here, which is that a rate of return is to assist the court to determine the return to be expected from the investment of a sum awarded as damages. So the whole purpose of this is in relation to a lump sum and not to a PPO.
Thank you, Chair. So I will listen back to that because it did interfere a bit on my connection. Apologies for that. So my takeaway from that is, if a claimant does go down the periodic payment route, because they've gone that route, they would have a zero discount. It wouldn't be applicable.
Yes, that's right.
Yeah, thank you. Appreciate that. Thank you.
Thanks, Sinead. Thank you. Okay, members, I think that brings us to a conclusion of the consideration of the clauses. Kristen, do you want to just maybe summarise for us those issues that we'll want to return to?
Yes, I think members had indicated that they may want to return to the 0.5% further margin, though at this stage they're not minded to make changes to it. And I think the other issue was on the periodical payments orders, and just whether you've got enough information to clarify the position and you're happy, or whether there is anything else that you want to consider, or you want to come back to that one.
Okay. And to conclude this, members, the formal clause-by-clause consideration will be on the 7th of October. So that would conclude our consideration of the Damages Return Investment Bill. Can I thank Martin for being with us, and as always, it's appreciated the time and his involvement in this issue, and also to the bill clerk who has listened in as well in relation to this particular part of our proceedings today. Thank you very much for your time. Thank you.
Thank you.
Thanks, Martin. Members, that brings us to item 5 of today's business, which is the Protection from Stalking Bill update. And that is at pages 270 to 341, setting out the update on the current position in relation to the Protection for Stalking Bill. The formal oral evidence sessions on the bill were completed in June 2021, following which the committee agreed that a summary of the issues raised in the written and oral evidence should be sent to the Department for written response. The Department of Justice has provided a written response outlining its comments, positions on the issues raised and the evidence received on the bill, and the departmental officials will attend the meeting on the 14th of October to discuss the issues and answer members' questions. The Department's response will be uploaded to the electronic committee bill folder for members and will also be included in the pack for the meeting of the 14th of October. The Examiner of Statute Rules was asked for her advice on the delegated powers in the bill and drew attention to clause 17 of the bill that provides that the Department must issue guidance to the Chief Constable about the exercise of the Chief Constable's functions under the provisions of the bill relating to stalking protection orders or interim stalking protection orders. The Examiner suggested that the committee may wish to consider whether it may be desirable to place upon the face of the bill a requirement to lay the guidance before the Assembly, and the Committee agreed to seek the views of the Department on this proposal. The Committee considered the response from the Department at its meeting on the 24th of June and agreed to request a clarification on the Department's decision not to accept the Examiner's proposal of its decision to also realise from its original to resile from its original commitment to lay the guidance in the Assembly for information purposes. The Committee also advised the Department that if it did not intend to bring forward the proposed amendment, then the Committee would consider doing this. The Department has responded, setting out the reason for the position it had adopted and indicating that it is happy to be guided by the Committee, and if members prefer, it will bring forward an amendment in relation to the Examiner's proposal to place on the face of the bill a requirement to lay the guidance set out in clause 17 before the Assembly, and you wonder why was there all the need for that to take place over the last number of weeks. It amazes me why we got to this point. But anyway, I see Rachel also smiling about that. I suspect she's going to say something similar. Rachel?
Yes, Chair. I mean, it just seems like a bit of a sort of wasted promise and waste of paper going back and forth. But I mean, just in terms of the point made, I mean, I would be very content for the Department to draft an amendment as long as we could see it, yes. And also just to see what it says. And I know that they would let us see that anyway, but it would be good to see that. And also, Chair, if the Department are intending on bringing any other amendments forward before consideration stage that we might want to discuss as a committee.
Yeah, and I think those are valid points. We will ask if we possibly can see the draft of the amendment before the meeting on the 14th of October. We'll certainly make that request. The Department has also responded to the Committee's request for information and clarification on several issues following the consideration of the research paper that have been commissioned on online trolling and abuse. And the Department has confirmed that specific legislative provision for online offences that are already criminal offences offline is not required, and that in the context of the Stalking Bill, it would be possible to secure a successful conviction based on online stalking behaviour. It also there's also, no legislative gaps have been identified at this point in the terms of legislation within the Department of Justice remit, and the Department also provided information on the work being undertaken by the Department for Digital, Cultural, Media and Sport on online safety bill to establish a new regulatory framework to tackle harmful content online and to ensure the criminal law is fit for purpose to deal with online communication. So I suspect, Rachel, the answer to your second question was they have no further intention to bring any amendments. So that maybe Christian, am I accurate in saying that would be a fair summary given the responses in relation to the online trolling and the correlation and consideration they've given to what's happening in relation to the safety bill?
Yeah, I think in that area they seem to be implying that they're covered and they don't need to bring anything forward. I think there's always a tension because some of this it's not devolved, so therefore some of it has to be done across the water. But we will ask about the bill in general because I suspect there may well be amendments in other areas that they are considering, but we will double check that and see. Okay, thank you. Thanks, members.
Chair.
Yes.
Sorry, it's just a thought. Is it worth sending any of our queries we may have in relation to this in advance, so that they're prepared when they come before us?
And to the department?
Yes.
Yes, I think we'll make them aware of the outcomes of these, what we've done today, so that we're not leaving it until the 14th, so that they're aware of the issues that were raised today. Yeah, okay. Thank you. There are 4, just to advise members that 4 of the informal meetings with victims of stalking have taken place, The committee staff will be in contact with members to identify suitable dates for the rest of the meetings, with the aim of completing them by mid-October, and we've tried to accommodate them as best as we possibly can. Also, that correspondence has been received from an individual outlining her personal experience with the Metropolitan Police and his views regarding how stalking protection orders can be misused and journalists face prosecution for doing their job in public interest. That's just for members to note and to consider. Unless there's any further issues to raise in that, we'll then have seek clarification and forward information to the officials prior to their attendance at the committee on the 14th of October. Thank you. Item 6, the Police Crime Sentencing and Courts Bill, proposed legislative consent motion. This is pages 343 to 357 of today's pack. At our meeting on the 9th of September, the committee considered the response dated the 17th of August from the Department of Justice on issues highlighting in correspondence from the Northern Ireland Human Rights Commission, along with a number of specific issues raised by the committee in relation to the proposed legislative consent motion on the Police Crime Sentencing and Courts Bill. The committee noted that a further provision may be included in the LCM relating to the issue of audio and visual links in criminal proceedings, and agreed to request further information on this, along with more detailed information on the risk management processes agreed between the police force and the probation services across the UK. The Department has responded indicating that it is no longer proposing to include the additional provision on the use of the audio and visual links in the criminal proceedings in the LCM. Instead, provisions in the Coronavirus Act 2020 can be used to allow the extension of the powers for the courts to utilise remote hearings until primary legislation can be taken forward following the Assembly elections, whenever they may happen. Further information has also been provided on the management of sex offenders, the framework which is provided by the public protection arrangements for Northern Ireland. And the committee also agreed to send the Department's response to the Human Rights Commission, and it has been asked to provide any further comments it may have by tomorrow, which is the date given, the 24th of September. So it's just whether or not there's anything else in relation to that that members wish to seek, whether they want to get further additional information from the Department, or whether we wish to submit any views or comments in regards to the issues raised in relation to the Police Crime Sentencing and Courts Bill. Chair,
I just have a concern, that there would be no protections put in place for the courts to continue using those remote hearings if that extension period runs out and there is no primary legislation hasn't put in place yet. There doesn't seem to be a sort of fallback option there. Hopefully that won't happen, but if the Department has any plans or any ideas to mitigate against that potential scenario.
Okay, we can write to them and ask. Okay, agreed. Thank you. Okay, members, that brings us to item agenda number 7, the update on progress of the Public Services Pension and Judicial Officers Bill and associated legislative consent motion. That's at page 360 to page 416 of today's papers. We had previously considered the outcome of 2 consultations carried out by the Department of Justice in relation to the McLeod judgment and the reform of the judicial pensions and on the mandatory retirement age for devolved judicial office holders, and agreed that it was content in principle with the proposal to proceed with the legislative changes by way of a legislative consent motion, subject to the sight of the relevant Westminster legislation. The committee subsequently noted correspondence from the Committee of Finance regarding the forthcoming LCM memorandum for Public Services Pension and Judicial Officers Bill, which will give effect to changes in public sector pensions in line with the McLeod judgment and make other provisions in relation to judicial pension schemes. The LCM was laid in the Assembly on the 6th of September by the Finance Minister, and the reforms are expected to take effect from April 2022. The Committee for Finance is currently considering the LCM and has written to other relevant statutory committees to request their views. And so whether or not the draft response to the prepared outlining the scrutiny the committee has undertaken on the changes in relation to LCM to reform the judicial pensions are covered in the LCM, and are members just content with the approach of us, anything else that we need to do in relation to that?
Content.
Okay. Okay. In view of the short time allowed for consideration by an LCM by a committee, a response will be prepared and circulated to members for consideration and approval by the close of play on Monday, so it can be provided to the Committee for Finance in time for the consideration of our meeting next week. That brings us to item 8, the SL1, Magistrates Court and County Court Appeals, Criminal Legal Aid Costs Amendment Rules, Northern Ireland 2021. And that information is at pages 418 to 465. The Department intends to amend the Magistrates Courts and County Court Appeals Criminal Legal Aid Rule Costs Rules, Northern Ireland 2009, which prescribe the remuneration payable to solicitors and counsel for criminal legal aid in Magistrates Court cases and County Court appeals. There is a statutory requirement to review the rules at least every 3 years, and the purposes of this statute rule, which is subject to the negative resolution procedure, is to give effect to proposals arising from the second statutory review. The Department has consulted with the statutory consultees as well as the Law Society, the Bar Council and the Director of Public Prosecutions, and a consultation on the second statutory review of the 2009 rules was undertaken in November 2017. The committee received a briefing on the outcome of that consultation in March of 2021, during which officials advised further consultation will be undertaken on the rules. This targeted consultation took place from the 21st of July to the 1st of September of 2021, and the Department has outlined details of the 2 responses received but the committee has not been provided with the full details of the responses to the consultation and or a post-consultation report. And it's just really to get your agreement to ask the Department to provide the full details of the 2 responses. I have to say it's not a huge amount of responses that they have to give us the information on, and if you're agreed, we will ask for that, and whether or not there's anything else that we need to be seeking clarification on at this stage. Okay. Sinead?
Yeah, sorry, Chair, just to say I was a bit alarmed when I saw the level of the increase, and how did we ever end up in a position where we had to move from £115 to 230? You know, something has clearly gone wrong, or there's been a stall somewhere if the 230 is the correct figure. I'd just like a wee bit more explanation. It just seems
we can ask for clarification, or justification maybe is better than clarification.
Yeah.
Okay.
Thank you.
Okay, thank you. Okay, members, if we can content with that, then we'll move to item 9, which is the SL1 rules in the Court Judiciary. I'll get that right before the end of this.
That's your homework.
That's my homework, to try and get that pronunciation right. It's at pages 467 to 474 and of the pack today. And this item and the following 5 items are amendments to various court rules related to the commencement of the Criminal Finances Act 2017 in Northern Ireland. The first proposed rule will amend the rules of the Court of the Judicial to reflect the processes and the requirements for the unexplained wealth orders and interim freezing orders, which were inserted into the Proceeds of Crime Act 2002 by the Criminal Finance Act and came into operation on the 28th of June. The court rules will specify the process and the requirements for an application for a UWO and the process for variation and discharge of UWOs. They will also specify the court processes to apply for an interim freezing order, including that such an application may only be made where the court makes UWO along with the processes in respect of other matters relating to interim freezing orders. The rule will be subject to the negative resolution procedure, and our members Content with the proposal for the statute rule? Content? Sinead? No, that's okay. No, thank you.
Right.
No, that's okay. Thank you. Okay, item 10, the Magistrate Court's detention and forfeiture of seized cash amendments rules, Northern Ireland. That's at pages 476 to 479. And again, that the Criminal Finances Act 2017 extended the powers of the POCA for search, seizure, and the details, and applies for the continued detention and forfeiture of cash to the Director of the Serious Fraud Office. The purpose of the proposed statute rule, which is subject to the negative resolution procedure, is to amend the Magistrates Court's detention and forfeiture of seized cash rules, Northern Ireland 2003, to clarify that a copy of an application for release of detained cash to set aside the forfeiture of cash made under a forfeiture notice or for compensation shall be sent to the Serious Fraud Office. Are members content for the proposal of the statute rule? Content? Item 11, SL1, is the Court's detention and forfeiture of listed assets. That's at pages 481 to 484 of the meeting pack. Again, it's in relation to the Criminal Finances Act 2017, where it inserted a new power to the POCA in relation to the search, seizure, detention and forfeiture of listed assets which were commenced in Northern Ireland on the 28th of June 2021. The proposed statute rule is subject to the negative resolution procedure. It will create a new set of magistrate court rules to reflect the court's processes, including court forum for dealing with applications in respect to these powers. Listed assets are currently designated under the legislation as precious metals, precious stones, watches, Arctic works, face value vouchers and postage stamps. So it's whether or not you are content with the proposals of the statutory rule. Content? SL1, item 12, the Magistrates Court's freezing and forfeiture of money in bank and building society accounts. Rules, Northern Ireland 2021. Pages 486 to 489 of the meeting pack is the relevant papers. Again, it's in relation to the Criminal Finances Act. 2017 inserted account freezing and forfeiture provisions into the POCA. The powers are available and where there is at least £1,000 in the relevant bank or building society account, and where there is suspicion money is recoverable property within the context of the POCA or is intended for use in unlawful conduct. The powers were commenced in Northern Ireland on the 28th of June 2021. The purpose of the statutory rule, which is subject to negative resolution, is to create new magistrate court rules to reflect the court processes and requirements for applications for the freezing, forfeiture of money in relevant bank and building societies accounts. Members content with the proposal of the statutory rule? I think this is the last one of these in relation to the Magistrates Courts. It's the Proceeds of Crime Act 2002, Confiscation Amendment Rules, Northern Ireland 2021, and that information is at pages 491 to 496. Section 215 of the POCA provides Magistrates Courts with the power to enforce a confiscation order. The court can order that a defendant's money seized by the police or Her Majesty's Revenue and Customs under the Police and Criminal Evidence Northern Ireland Order 1989, PACE Northern Ireland Order, that has to be paid into a bank or building society be paid to the court in satisfaction of a confiscation order. The Criminal Finances Act 2017 extended the powers of the POCA beyond the police and HRMC officers to allow all enforcement officers who have the power to seize money. It applies to the money that has been seized under any power relating to a criminal investigation or proceeding with, and also applies to money, however, it is held by law enforcement and not just a bank or building society. The provisions came into operation in Northern Ireland on the 28th of June 2021. The statute rule, which is subject to negative resolution procedure, is to amend the Magistrates' Courts Proceeds of Crime Act 2002, Confiscation Amendment Rules, Northern Ireland 2003, to reflect the amendments of the POCA and to allow the court to deal with seized money in these wider circumstances. Are members content that the statute rule is made? Thank you. And just have a few more of these. Hopefully we will get through them. Excuse me. Item 14, SL1, the making available on the market and supervision of transfers of explosives amendment, EU exit regulations, Northern Ireland 2021. This information is at 498 to 526. At our meeting the 1st of July, the committee considered the proposed statute rule, which will make subject to a draft affirmative resolution to amend making available on the market the supervision of transfers of explosives 2016 regulations. The 2016 regulations implement EU Directive 2014/28 EU, the overall purpose of which is to ensure that civil explosives can only be placed on EU market if they are safe. The 2016 regulations need to be amended to maintain Northern Ireland's alignment with the directive and ensure that UK NI meets its obligations under the protocol in Northern Ireland, under the protocol in Ireland/Northern Ireland to the withdrawal agreement. The rule will also introduce provisions with regards to the UK NI indication. The committee agreed that the request further paper from the Department clarifying the position in relation to GB in Northern Ireland with regards to the proposed statute rule and the making available on the market and supervision of explosives for civil uses. The Department's response included a table clarifying what the position in GB was and what the position will be in relation to the proposed Northern Ireland statute rule. Are members content with the proposal of the statute rule, or whether any further information or clarification is required? Peter?
Chair, I suppose just as with the position last week in terms of the SL1s, obviously with direct reference to the alignment with the protocol, obviously just to record sort of the concerns in relation to that things. Appreciate it. So they're recorded the same way.
Okay, and if we're not content, we'll record the information set out in the previous minutes of today's meeting that were approved. Agreed? Great, thank you. Agenda item 15. Agenda item 15, the annual renewal of the Secretary of State's discretion under section 1A7, the Prisons Act Northern Ireland 1953, as amended by Schedule 4 of the Northern Ireland Act 1998, Evolution of Policing and Justice Functions Order 2010. That's at pages 528 and 540 of the meeting pack. Following the devolution of justice, matters relating to national security remain the responsibility of the Secretary of State for Northern Ireland. During the preparation for the devolution of justice, the need for a special security-related information handling agreement in the Northern Ireland Prison Service was identified. Decided that a legislative instrument. Somebody's not muted. I think they're muted now, maybe. It was decided that a legislative instrument in the form of a direction should be created. The direction sets out arrangements for how Department of Justice officials, when dealing with operational prison matters which remain in the reserve field, are to be treated as officers of the Secretary of State, subject to his direction and control, and how they handle protected information. Direction has been renewed each year with no amendment since 2011, and the Minister of Justice is of the view that the direction remains fit for purpose, that it does not need amended, and that it should be renewed from October 2021. Before she agrees to the renewal, the Minister would, however, appreciate the views of the committee, and it's whether or not the members are content to note the intention to renew the Secretary of State's direction unaltered for and a further 12 months from October 2021, or whether they wish to submit any further views or comments in relation to the matter by the Department. Content? Thank you. Item 16, EU exit and justice-related issues. In pages 542 to 582, we have the relevant papers. At the meeting on the 16th of September, the committee considered further information provided by the Department of Justice on the impact of the Northern Ireland Protocol on the justice sector, including any funding implications and the potential impact of the Lango Convention on cross-border civil justice cooperation. At that time, members requested a written update from the Department on the EU exit issues and how the new justice arrangements are working in September 2021. The Department has provided a progress update on a number of key issues areas across law enforcement, security and criminal justice. This includes progress on key justice measures, extradition, surrender, passenger name recognition, Europol, the EU Law Enforcement Agency, Eurojust, the EU Agency for Criminal Justice Cooperation, exchange of criminal records, mutual legal assistance, assets freezing and the confiscation and IS2. The Department has also provided detail on recent developments in respect of the Northern Ireland Protocol, costs, trade, cooperation agreement, TCA, governance, data adequacy, bilateral ministerial events and the Lango Convention. The Assembly EU Affairs Manager has provided copies of correspondence between Robin Walker MP, Minister of State for Northern Ireland, Simon Hoare MP, the Chair of the Northern Ireland Affairs Committee, regarding the Government's response to the Committee's report on cross-border cooperation and policing, security and criminal justice after Brexit. The relevant papers can be found at pages 562 to 569. The Committee had previously asked the Department of Justice for its response to the recommendations in the Northern Ireland NIAC report, and the responses from the Department have also been included in today's pack. Can I just advise members that Robin Walker has identified that the PSNI had received an extra injection of funding to prepare for EU exit at the end of the transition period, which has now come to an end. And so it's to ask the Department, maybe one thing coming out of that is to ask the Department of Justice to clarify whether the funding referred to by the Minister of State is separate to that required by the PSNI in respect of the protocol for the discussions with the Treasury, which are ongoing. So we just need clarification from the Department, maybe in relation to that, and then to note the information from the Department and all the other relevant information in relation to the EU Affairs Manager, unless there's any other points of clarification that we need. Sinead.
Thanks, Chair. In the briefing, it states that the Member States can refuse to extradite their nationals to the UK, and it also says that bilateral work's underway with individual states. So obviously it would be prudent for us here to understand what the current status is, what the arrangements are with the South. Okay. And also as well the new specialised committee on law enforcement, what, if any, role will the Justice Minister have in that? And I know there's a meeting in October, and I think it'd be prudent for the committee to get an update following that meeting as well.
On the first point, well, that we can seek that clarification from the Department, can't we, Christian? It wouldn't have to go.
Yeah, we'll see where we can get it from, but
it wouldn't have to go to the police.
Well, we'll check first. We'll see, but we'll ascertain who get the information from. We'll write to one
Peter?
another.
Just on the initial point we were saying about it in terms of the money from the transition point of view, and then what's bid towards Treasury. I suppose just more generally, if we can also just ask in terms of EU exit-related matters, as regards to the police, any, be it out of the Police Department of Justice, what their assessment of where financially they're landing in it, if you know what I mean. You say it clumsily put, but if you know what I mean, so we can get a sort of a full picture of that.
Because there was something in the October monitoring round in relation to additional pressure, and was it not? It was something about 3.7 million. There was something, I think, in relation to. So it just. And
again, part of that, I suppose, to try and get a little bit better picture in terms of the financial pressures. We're all aware sometimes, depending on bids, either the monitoring run or indeed it can be a sort of a one-off pressure, which is time limited, or even similarly a one-off grant of money for the rest of the year. But then what's the baseline pressure, I suppose, as well, type of thing.
Okay. Rachel?
Thank you, Chair. Yeah, just in terms of the October meeting on the Trade and Cooperation Agreement, it's certainly welcome an update by the Department of what was discussed when the time is right. And also, like Sinead, just in terms of clarity on extradition, could we ask what the additional safeguards are and how they work, and set out even for comparative purposes, just so we can see what the difference is between the process now and the process pre-EU exit?
Okay. And Gemma?
Yeah, thanks, Chair. It's disappointing and concerning that the UK has not yet managed to secure its reaccession to the Lugano Convention. Approximately how many litigants will be affected per year by our exit from the convention? Do we know, or can we find out?
No, I don't think that we ever got any. I don't think we ever got an actual number, but I think we can seek that clarification. Yep. Thank you.
Okay, thank you.
Okay, thank you. Nobody else in relation to that. Then that brings us to item 17, correspondence. And there are 4 items of correspondence at pages 584, 839 of today's pack. I just want to draw your attention to one of those items, and then if there's any other items that members want to raise. Item 17.4 at page 633 to 835 is correspondence from the Committee for Communities, providing a copy of a letter from the Department for Communities regarding the transfer of the appeal service and the rents assessment panel from the Department for Communities to the Department of Justice. The Committee for Communities has also drawn the Personal Independence Payment Second Independent Review of the Assessment Process Report 2020, and in particular the recommendations relating to the scrutiny of appeals to members' attention. The committee previously considered information from the Department of Justice regarding this proposed transfer and agreed to seek further information on a number of issues to assist in its consideration of the matter. The committee also agreed to write to the First and Deputy First Ministers regarding the importance of ensuring accessibility of tribunal panels to people accessing benefits. And so, is there anything more in relation to the Department of Justice or in regards to the recommendations relating to the scrutiny of the appeals within the PIP second review of the assessment process report of 2020 that was shared with us from our colleagues in the Committee for Communities? Any comment? Content? Okay. Thank you. And if there's anybody has any other queries, questions in relation to correspondence, if Rachel?
Thank you, Chair. Just very briefly, and it is on the item that I've now just lost. Sorry, item 17.2. It's just regarding the, I can maybe seeking an update from the department on taking the forward work to improve the provision of RSE in our schools. And that was a commitment that was given by the previous Education Minister, and perhaps as he's in committee today, maybe he might be able to give us some information about where that is. But if not, could we ask the department if they have had any information in relation to the cross-sectoral work that was being looked at improving the provision of RSE? And that was including a review of the minimum content order, because the letter makes no mention of this work that is and or was going on in the update on child sexual exploitation and abuse there.
Okay, we'll write to. Do we write to? Clarify that for me, Christian. Do we write to the Committee for Education, or can we write? No, we write to the department.
We'll write to the department
involved.
First of all,
yes,
because they had flagged it up. So we can write to them to see what information they have, and then, if necessary, we can look to write to the Department of Education if we have to.
Okay, thank you. Thanks, Rachel, for that. If there's nothing else, then that brings us to item. Well, there's no business that the chair has to raise, thankfully. Any other business? Okay, if there's no other business, then members, The date and time of the next meeting is on Thursday the 30th at 2 p.m. in the Senate chamber, and can I apologise in advance of my absence at that meeting and thank the Deputy Chair for willingly agreeing to chair the committee, and I hope there is about 40, no I don't hope that, of SL1s, because those things really do take years of my life reading. But thank you, Deputy Chair, for your help, and thank you, members, for your attendance and your help today, and I wish you an enjoyable rest of this afternoon. Thank you.
Thank you, Chair.
Thank you, Chair. Thank you, Chair.
Okay.
Northern Ireland Assembly, Committee Room 30.